Hello, everyone. Thanks for joining us today. I'm David Rubin from Nutter, McLennan and Fish, and I'm joined here by Rebecca Gallup, Director and in-house counsel at E-Ink Corporation, as well as some of my colleagues in the Labor and Employment and Benefits Group at Nutter, Chris Lindstrom, Natalie Capilazzo, and Anuj Ketarpal. Want to say thanks to ACC for hosting this today. Really appreciate the opportunity to work with them again. The agenda today, and I think that's probably the next slide, maybe the one after. Thanks. So our agenda today, and it's funny, I think we worked this agenda out months ago, and I think we probably thought we'd have a lot of answers then. I think you'll see that we probably have as many questions now as we did then, but these are, I think, all very interesting and important subjects to talk about that are being talked about every day that we find with clients on an ongoing basis. So we'll start off talking about the policies necessary for a sustainable hybrid workplace. We're going to talk about how to attract and retain talent in this really challenging environment. And we're going to talk about the future of vaccine, booster, masking, and testing requirements and exemptions. We'll talk about the OSHA general duty clause, given that the OSHA testing or booster, or excuse me, the OSHA vaccine and testing rule went out the door. We still have the OSHA general duty clause to deal with. We're going to talk about how to deal with issues of FMLA, paid family medical leave, and ADA requirements in a hybrid workplace, which is an issue that comes up seemingly daily. We're going to talk about worker confidentiality issues. And then in the end, we'll talk about what we see and are expected potentially for issues of disputes, litigation going forward arising out of all of these issues. We are going to try to address questions as they come up, so we'll be monitoring the Q&A and the chat box below. And so if you have questions or issues that you want us to comment on, by all means, please enter your Q&A or enter your question or comment into the chat or the Q&A, and we will try to get to them either during the course of the program or hopefully at the end if we can. And I know we are, when we're done, we will be sending out to all the participants a document containing the links to some of the more important and useful resources that we're relying on and looking at and maybe talking about. And also remind everyone that this program will be recorded and available on both the ACC website and on the Nutter website. So to start, I think the first question will be to Chris. And Chris, what are the key policies necessary for a sustainable hybrid workplace?
All right, thanks, David, and welcome everyone. And I just want to echo what David said about asking questions, putting them in the Q&A and the chat, just because the content that we've prepared for today is essentially based on the questions we've been getting from clients over the past year or so. So, and there are always more questions out there, and sometimes those questions and the potential answers are valuable to some of your colleagues as well. But to get to the core of it in terms of a sustainable hybrid workplace, the reason why we're asking that question and trying to answer it now is that as of the end of 2021, one of the major consulting firms did a survey and found that 9 in 10 companies are switching to a hybrid work model on an ongoing basis, not just for the emergency of the pandemic. And in order to attract and retain talent, which we're going to discuss later, most employers recognize that they need to consider making permanent some of the hybrid or remote working environments that they've been utilizing or maybe haven't been utilizing yet, but see some of their competitors doing. There's no one size fits all approach for hybrid workplaces. It's going to always depend on the industry, the size of the employer, the makeup of the jobs and the employees, the overall morale of the company at the time, where you're positioned in the market. But I'll share what I've noticed is some of the best practices based on advising clients on establishing longer lasting hybrid workforce models. And the most important piece of advice is that you need to set expectations for your employees and maintain consistency absent extraordinary circumstances. So for employers, this means the first question is whether you're able to set defined rules sufficiently to have a formal written policy. The alternative that a lot of employers are utilizing is to kind of have an unstated understanding of flexibility for employees and wait for individual remote working requests and approve them on or not allow them on an ad hoc basis. And I tend not to recommend this if you can avoid it, because it's too rife with inconsistencies and surprise. And instead, you probably want to have a written remote work policy that clearly states the overall expectations, which employees are eligible for remote work, which employees are not eligible, the requirements for working remotely, including the ability to still meet the essential functions of the given position. And in this policy, you need to consider whether it's going to be 100% flexible or partially. In other words, will there be requirements that employees work on site at least X days a month to make sure that you can continue that team approach, even if the position can be effectively done remotely all the time? Another consideration a lot of employers are looking to nowadays is flexible work hours, whether it's on site or remotely. And more employers are open to this approach because they realize that, in order to attract talent, you may have to think out of the box in terms of the traditional working hours. So then once you have your policy, which again is going to have as many specifics as you feel you can include, the most important thing is consistency in application. And this is both from a discrimination standpoint and also employee morale. If the application of the policy results in a greater number of older workers, of women, or members of other protected classes being denied remote work for one reason or another, this could lead to a discrimination claim. And this is because the flexibility or not having this flexibility could be considered an adverse employment action. Many employers are permitting their different departments or divisions or units to write their own rules. It's obviously true that HR probably has to be more on site than the accounting department. But you have to think through carefully what the legitimate reasons are and just not allow the head of each department to make his or her own rules, because that always leads to, beyond legal problems, but obviously morale problems. And you want to make sure that your policy is not just seniority based. If the entire C-suite is staying at home and everyone else is coming in the office, that's going to be a problem. And on the other end of things, you also have to make sure you have the buy-in of your senior management. And so you want to make sure everyone that has a voice in this, everyone that leads each department should be consulted on what's going to work for them, because those are the people who are going to have to make sure they follow the policy, and also make sure that they're comfortable with employees taking advantage of the policy. Any remote working policy has to include flexibility, because if there's one thing we've learned the last couple of years, we don't know where this thing is headed at any given moment. And so this means you can't make promises as to specific employees or generally as to what is always going to be the case. You want to allow yourself some flexibility, either to go more remote, or if you find that the business is suffering with too much remote working, you may have to figure out to become more of a traditional in the workplace working environment. The other aspect that really comes up a lot is the treatment of confidential materials. The first part of this is cybersecurity protections. You can't turn a blind eye to the IT infrastructure of your employees when they have a kind of a home setup. During the pandemic, there was always a bit of a leniency in this respect, because there was a community understanding that everyone was doing the best they could in terms of their home office setups. But now, if you're going to have a formal remote working policy, and if it's going to be permanent, you need to make sure that each person's home setup is going to be secure, because obviously the risk is on the company. no one's going to blame the employee in the end when customer records are shared or your trade secrets of your company are somehow put at risk. And this especially becomes true at the time of termination. So, you want to make sure you have checklists about how you're going to recover any company property, company files, etc. when someone leaves either of their own volition or on a termination. It used to be that employers only did kind of forensic analyses of departing employees when there was a reason to have concern or if there's a non-compete issue, but now more and more it's becoming a regular practice that you kind of include that as part of your departure checklist. And another aspect of this is the location of the employees. If they're in other states and working remotely, you may, as the employer, may be subjecting yourselves to both the tax laws and the employment laws of those states. For instance, Colorado passed a fairly onerous equal pay law recently that means if you have a single employee working there, you all of a sudden have to look at your job postings and compensation issues. New York City is about to implement a similar law. I think it comes into effect in May. So once you have remote employees and those employees are out of the state that your home office is in, you're definitely going to have to look at the laws of those states right away. And then two final issues I wanted to bring up. One is performance reviews. If people are working more remotely, I've stressed this to a number of clients that it really is imperative to make sure that you have consistent written performance evaluations, because you need to, if people are not in the office together, you need to have a better record of how people are performing, not only from a perspective of setting a record for a termination, but also so that employees know where they stand at any time. And the other thing you have to watch out for, especially for remote working environment, is overtime laws, because studies have found that remote workers work more than 40 hours a week at a much greater clip than employees who are on site. And so you have to make sure you look at your policies to make sure that any non-exempt employees are not working overtime, or if they are, that they're being compensated as such. So I have a feeling that we're going to get a few more overtime suits as hybrid working environment becomes more common.
Thanks, Chris. Actually, I would just ask this to Becca. From the in-house perspective, Becca, what do you see as the keys to that you finding do or do not work in having a remote work environment?
So thanks for the question. I think Chris hit the nail on the head with his discussion of what a flexible work policy needs to look like. Some things that we found to be very important are upfront communication and expectation setting. Our policy includes, and I think every discussion about remote work or flexible work needs to include a discussion of expectations for how communication is going to look between a manager and the team and the person working remotely. What meetings are they expected to attend, whether they be in person or can those meetings be attended remotely, and also productivity requirements. At E-Ink, we have a mix of employees, some who work in labs, and lab work can't be done remotely, at least not safely. So you need to have open communication and expectation setting of what needs to be done in the office, when it needs to be done by, how that's communicated, and what that communication looks like.
Thanks. Well, that brings us to the next question, and Becca, keep your microphone on because I'm going to be asking you on this one. And I'm not sure this is so much a legal question at this point as a business question that we're all facing, and that is, how do we retain and attract talent in this environment? I mean, it is just, I've never seen anything like it. I've been practicing for a long time, and this is new to me as well.
Yeah, that is the big question right now. And I think as an in-house lawyer, it's not something I expected to be so involved in when I started, but but you do get involved. And I think we're all seeing it. I think everyone knows it's a difficult market for employers to both attract and retain employees right now. And I'll touch on some of those reasons, but in terms of attracting, personally, we are seeing lots of open positions right now and a smaller pool of potential employees. Though in the last few months, I'd say we are seeing a shift back to something more along what we would expect. But while there is that imbalance, I think we need to, as employers, be mindful of thinking outside the box when it comes to attracting employees. And I know one thing we have done is look at our referral bonus policy, which is something we hadn't looked at in quite some time, and increase the referral amounts to something that's more in line with current times, and to lean on current employees for suggestions for people they may know to fill open positions, because often it's your current employees that know the needs of the business and know the needs of the position, and may have people that they know out there who are also looking. In terms of retention, when it comes to hiring, I think gone are the days where you could be kind of lackadaisical as an employer and take a month or two to have the prospective employee meet everyone on the team and really get to know people before you make an offer. We're finding that you lose potentially very valuable employees if you drag your feet. That's not to say that we should ever lose the ability to properly vet prospective employees, but I think we are finding that we need to move faster, and I think that's where we leverage video conferencing. We can't wait to bring everyone until there's a day when everyone's free to do the 4-hour-long in-house interview. I think you need to be a little bit more nimble and more flexible, and also know exactly what you're looking for in an employee, and know where you can be flexible in your requirements, whether it's with salary or with the ability to offer remote work or flexible work schedule. I think those things are important. In terms of retaining current employees, I know everyone's talking about the Great Resignation. It's made it to the media, so it's everybody knows about it. So it must be going on, and it is. And it's hard to pinpoint the exact reason why folks are leaving. I think there are a lot of reasons. Some of them COVID related, some of them COVID adjacent. For example, I know in the town that I live in, after school care is a big issue right now, and that's related to COVID issues. And it's causing a lot of people to not be able to work traditional 40-hour work week. And so, there may be attrition due to that. So when you do have employee attrition and you do have employees leaving, I think often the push is to do the exit interview, figure out what went wrong, figure out why they left, and really kind of pin it down to one particular issue. And we're not always going to be able to do that. There may be a bunch of reasons. We may never know the exact reason or the exact suite of reasons why someone leaves. In my opinion, the more important thing may be to find out why employees are staying. And that requires open communication with your employees, whether it be through surveys or one-on-ones with managers or kind of stay interviews. Figure out why your employees are leaving and if there's anything that's impeding their ability to meet their goals. And if there is, figure out if you can remove those barriers. That in the end may be more important than what you learn in an exit interview.
Thanks. I do a fair amount of labor relations, union management relations, union negotiations, et cetera. And I know that most of the attendees, if any, are likely not unionized. But I do think there's some things that happen in a unionized workforce that are illustrative here and are broadly applicable. So I'll raise a couple of them that we've seen, and that is one, a lot of the tension in union negotiations going on right now arises from the fact that employees are overwhelmed with too much overtime, too much trying to fill in for absent co-workers or unfilled slots, that in turn causes them to leave, which in turn exacerbates that problem further. We've seen that over and over again in a number of different industries. We've seen it in manufacturing. We've seen it in social work, in financial services. They're all experiencing that same problem, that the stress put on the employees that stay of trying to fill in for their coworkers and fill in vacancies is actually pushing them out the door, which just makes it worse. Another issue we've seen coming up in negotiations that I've never seen before, really, is I've had historically, companies, unionized companies would say that they have a trouble competing for business with their non-union competitors because the non-union competitors pay less, can undercut their rates, and bid out their work at a lower rate than they can because their wages are higher. And that's been turned on its head the last year or so, where unionized employers are frustrated that they can't unilaterally raise their wage rates because they have a union contract that constrains them. It's never seen that one before either. But again, it's come up in multiple union negotiations across a variety of industries, both whether it's in office work, manufacturing, healthcare, et cetera. It's the same issue arises again and again. In any event, so if we move on to our next subject, I'm going to ask Natalie to talk to us about how do we prepare for future vaccine or booster or masking requirements or exemptions, given we've gone around in circle on this issue now over the last year plus. And with the most recent, the OSHA testing standard being, we all rolled it out. We did our webinar on that one and, and that went away. So where does this issue go next? How do we deal with that?
Thanks, David, and hi, everyone. So as David mentioned, we obviously saw a lot of back and forth on this issue with the OSHA ETS. First, it was, whether it was actually going to take effect and then what the Supreme Court was going to do with it. I think maybe the one silver lining was that in the interim, even with all of that uncertainty, a lot of employers did sort of proactively take that as a reason to get a policy in place around vaccines, masking, testing. Many decided to just mandate flat out, which at the time seemed like it was probably the easiest option, given that the ETS sort of made testing kind of onerous. But now, without any sort of clear set of rules like the ones that were outlined by OSHA, it's really a moving target. And I think some employers might even be wondering at this point, with the general drop in cases, do we even need to have a COVID policy around vaccines and testing and masking? But I think that we would say yes, having some sort of policy is still advisable, at least for a few reasons. One, just common sense comfort of other employees. I think it's not hard to imagine a scenario where, especially with attrition issues in the pandemic, employees might be hesitant to return to work if they don't feel just some basic level of safeness and knowing what's going on. Similarly, for the comfort of customers, clients, vendors, and other third parties, this could also be a concern for your organization if you work with at-risk populations or elderly populations, or sort of any groups that would have concerns about what you as the employer are doing with regard to your employees. To be prepared in the event that there's another spike in cases and not to have to scramble to put something into place. To comply with the OSHA general duty rule, which Anuj and David will discuss in some more detail in a moment. And then in Massachusetts, just to follow the current guidance on isolation and quarantine, which are still just sort of applicable across the board. So I think that's why it makes sense to have some sort of baseline COVID policy still in effect. And sort of on this point, I think it's helpful to keep track of what's going on at the statewide and local level. For example, Massachusetts obviously lifted indoor masking requirements in most settings, and as a result, maybe it makes less sense for employers to have masking across the board. So keeping track of what's going on at the local and statewide level might help you sort of keep your policy up to date and just staying flexible with it as things change. Similarly, when the CDC changed its guidance on the timeline for isolation and quarantine, and then Massachusetts followed suit, that sort of allowed employers to build in some more flexibility in terms of not just keeping employees out for 2 weeks every time there was an exposure or a test. So sort of adapting policies as the science evolves and as government guidance evolves, I think will help employers sort of stay nimble on these issues. In terms of what you can do now to prepare for future changes, it's always a good idea to just sort of take a look at your organization's budget and what the costs of these types of changes might look like. For example, early on, I know we got a lot of questions, especially around the OSHA ETS, about the cost of testing and who bears that, and then similarly the cost of PPE and face coverings. And we've gotten some guidance from the Massachusetts Attorney General's office that basically says that the more restrictive the employer is with testing and masking requirements, the more likely you're going to have to cover the cost. So for testing, if you're dictating when, where, and how the employee gets tested, more likely than not, it would be on you to pay for it. But if, on the other hand, you're just saying, you know, you need a negative test to come back to work, and you're not sort of laying out the specifics, that cost would sort of stay with the employee. And then similarly with face coverings, if you are mandating a face shield or a respirator or a specific type of face covering, something with a company logo on it, those sort of bring you into the sphere of requiring a uniform, which would be have to be covered by the employer. Whereas if you have a general face covering rule in certain spaces or at certain times, that's that cost would again stay with the employee. But always a good idea to just sort of look at the budget and see if, you know, the rules change on testing and masking, what that cost might look like for you as the employer. And then similarly, reviewing your PTO policy, I think that building in time for obtaining and recovering from booster shots could be advisable. We've seen some states like New York have actually provided paid time off specifically for boosters. So that could be something that becomes more widespread as time goes on. And then just ensuring that you have a standardized approach in place when it comes to handling ADA requests for medical exemptions to a vaccine or booster requirement, and similarly religious exemptions. Just having a standard form or approach in place will help going forward, because as Chris mentioned, consistency is really key, and that applies with exemption requests too. So if you roll out or you have a mandatory vaccine or booster policy, treating those requests in a uniform way is definitely the best practice.
You know, Natalie, I received a question from a couple of clients that I thought was pretty interesting recently, is that if you're an employer who had a mandatory vaccine policy and maybe even a mandatory booster policy, are you in some sense required to continue with that policy once the next booster is available to everyone in the community? You know, now it's only in certain age groups. But if you've made the decision previously that it was in the best interest and the safety of your entire workforce to have a vaccine mandate, have you then already made that decision, and therefore you have to continue to follow through with every, because I think we can all assume there will be another wave in the fall, and requirements for and boosters will be available to everyone. So I just didn't know if you had any thoughts on that.
Yeah, that's
what employers should do, and whether they should start preparing now, whether they're going to mandate the next booster or not.
Yeah, thanks, Chris. That's a great question. I think a little bit of this is sort of wait and see, but in terms of whether you are absolutely required to continue mandating boosters and requiring proof from your employees going forward, I don't think there's a hard and fast rule that you absolutely have to. I think that at the time that vaccines initially rolled out and then subsequently boosters, we were in the midst of like the thick of the pandemic, and then we had Delta and Omicron. So it made sense to mandate the initial vaccines and boosters because of the direct threat sort of posed to your workforce at the time. And sort of as time goes on, I think that analyzing that threat level will be key to whether employers should keep mandating boosters going forward. If there's, we're kind of now, as you said, in another wave of boosters where people of a certain age group can get it, but not everyone can get it. So does it make sense to mandate it now? I think these are like tough questions that sort of depend on what your workforce looks like and how much of a threat COVID sort of continues to pose to your workforce. But I don't think that just because you mandated a first booster doesn't mean that you're automatically bound to that forever, going forward.
So at the risk of picking on you again, Becca, but I do wonder from the in-house perspective, and again, this isn't so much a legal question as, you can't talk about testing or masks or boosters or vaccines without it being a very loaded question when people have pretty strong reactions on different sides, from all different sides and all different perspectives. So from your sense, from the in-house sense, how do you avoid, I'll say nicely, making people upset?
I think the answer is that's impossible to do. You're never going to have a policy, certainly about these issues, which are hot button issues: masking, boosters, vaccines, even social distancing, or a quick requirement that people work remotely. You are never going to have a policy or a policy change that doesn't upset someone. And often, it's a very vocal minority who are upset, but that minority is important and they're vocal. So I think the key is to set expectations. I think that's what we found from the very beginning. No one wants to be surprised by this. The example I think of most is masking. When there was no, state mask requirement, and when companies were kind of on their own to make their own rules, we were very clear that, masks would be required, even though on site, even though there was no kind of outside requirement, for a time, and that we were going to watch the numbers. And when the numbers decreased, we would evaluate whether we could remove the mask mandate. And then when we were able to, we were very clear that, hey, we may have to reinstate the mask mandate. We told everyone that we were looking at, federal, state, local guidance. We were also looking at numbers, local numbers, in-house numbers, what's going on, in the community where our offices are located. We were very clear, in our town halls and in our communications that that's what we were looking at, and that's what we were basing our decisions on. So hopefully when we did have to make changes, nothing came as a surprise.
Thanks. One question has come up here on the screen before we move on to the next subject, and it's one that I know, Chris, you and I have talked about, and Natalie, you and I have talked about. So I'll ask you, Chris, if you want to address this one, and that is, how do you recommend that employers treat requests for religious exemptions that have the hallmarks of being manufactured and copied from internet sources, e.g. based on personal preferences and not sincerely held beliefs? And before I go, I just say, we've all seen the same form that's been floating around on the internet, requesting an exemption. Chris, how would you advise clients as to how to deal with that?
I mean, as with any of these, you have to take them on a case-by-case basis. But you're right that we have seen, and across different client employers, a very, very similar write-up of a person's sincerely held religious beliefs that mean that they cannot or are choosing not to take vaccine. And it is still, even if it has the quote unquote hallmarks of something taken off the internet, it is still very difficult to question someone's stated and expressed sincerely held religious beliefs. I have found that the issue that really is the one where you have to make a determination is the undue hardship aspect of it, because even if someone does have ask for an exemption due to a religious belief, if that exemption is going to cause an undue hardship on the employer, then the employer can deny it. And it's interesting that under the regulations, the undue hardship standard is lower on the employer end of it than in the disability or handicap exemption situation. So I have found that most employers have been able to really analyze whether or not it will be an undue hardship, and most of the time it is, either based on direct threat to other employees or based on what that per individual's job is. Now, if it's a truly remote job, it may not be an undue hardship if someone doesn't take a vaccine. But again, I think it's much harder to question someone's sincerely held religious beliefs than it is to really analyze that undue hardship aspect of it.
Thanks. Okay, so moving to the next question, the next issue for Anuj, and I will say, just to preface it, when the COVID pandemic started, there was no specific OSHA rules in place on how to deal with a pandemic in the workplace, other than the general duty rule, right? That you have to provide a reasonably safe workplace. We've been through fits and starts of regulation and non-regulation and industry specific, and we've seen litigation in the meatpacking industry. We've seen a lot done in healthcare. We saw the testing standard come and go, and now we're back with the general duty clause. So Anuj, going forward, how do companies comply with the general duty rule?
Thanks, David. As David just mentioned, the vaccine testing ETS was withdrawn after a Supreme Court's decision, and so we are now left with this general duty clause, which requires employers to take reasonable steps to abate any hazards pertaining to serious recognized hazards within the workplace, which does now include COVID-19. So while OSHA still does not have any specific guidance or specific regulation with respect to the majority of industries, it has issued guidance regarding preparing workplaces for COVID-19, including steps that employers can take to reduce their workers' risk of exposure to the virus. A link to that guidance is going to be provided in the handout that's going to be sent to all participants here, all attendees here. However, in general, that guidance follows the CDC guidance. That guidance is primarily advisory. However, it does incorporate the general industry specific mandates regarding PPE and exposure to hazardous chemicals. And so in order for employers to satisfy their general duty obligations to maintain a safe workplace, what employers should do is follow CDC's public health recommendations, which, as we have seen, depending on your area and the level of exposure and circulation of the virus within your area, has changed. And so it is a moving standard. And however, OSHA seems to follow the CDC's moving standard with respect to what best practices are. Employers should also continue to follow best practices within their industry, within their respective industries, as it pertains to cleaning, general cleaning, masking, PPE, physical distancing, testing and vaccination requirements and responses to exposures and illnesses. And of course, employers must comply with all other state and local and mandatory safety and health standards and obligations that they've already had, which are relevant to the industry. In the healthcare setting specifically, OSHA had in June of 2021 issued an emergency temporary standard and has withdrawn the majority of that temporary standard, aside from the non-record keeping portions. That those record keeping portions do remain in effect with respect to the healthcare industry, and OSHA has opened for public comment a proposed final standard for the healthcare industry. However, there is no similar final standard for the general industry as well. So the short answer to that is, in order to try to avoid liability under the general duty clause, what employers should do is follow CDC guidelines as they evolve, and subsequently will also be compliant with OSHA's guidelines as well.
So Anush raises the question of, so what is the reporting requirement? For outside of the healthcare industry, in a law firm or wherever, what is the reporting requirement as it relates to COVID cases?
Yeah, that's a great question, and it does present some difficulties for employers. So employers are required to record work-related cases of COVID on their OSHA Form 300 logs. If there is a confirmed case and the case is work-related and it complies with other OSHA reporting requirements, such as the requirement for medical treatment or a certain number of days away from work, or if there's hospitalization of some sort. Of course, as we all, just as individuals in the world, know, there is often difficulty determining whether exposure to a virus is work-related or not work-related. And so I think that does provide some difficulty for employers in that context. However, that's the general requirement is that if there is evidence that this is work-related and fits those other standards, and employers are required to record that on their OSHA forms. What they're not required to do is to record side effects from COVID-19 vaccinations, at least as OSHA has stated it now, through May 2022, so through next month, OSHA is not requiring that to be recorded on the OSHA Form 300, and they're going to reevaluate that at some point next month.
Thanks. I think your answer was great, and yet I think we're all still wondering. So what do we do, right? Because you're in a difficult spot as an employer to decide, is this something that's reportable or it isn't? And when we talk about confidentiality in a little while, I think we'll see how that plays back into that whole issue as well. But in fact, before we do that, I'm going to one more time, Becca, tell us, what do you guys do?
So I think, in addition to the work-related issue that Anu was just mentioning, the other piece that's tricky is their lost work, which is a requirement for OSHA reporting, especially when you're talking about a workforce that is remote right now. So you really have to look at, is the employee working remote all the time? Are they able to work? Are they just able to work remote some of the time and they're not missing work? It's a tricky and kind of long and involved calculation. There are lots of points that you need to look at. And so I think it's important from an in-house counsel perspective to be aware of all those facets, that you're looking at all of those. And you may have to do some analysis on a couple of different levels.
Well, that question, what you just said, I think shows that all the issues we've just discussed are now sort of layered on top of each other, right? They all.
Yeah, I mean, remote work changes a lot. And the other point I'll make about OSHA is, for folks to be mindful of the fact that some states have their own state-run OSHA guidelines that they need to follow. For example, we have an office in California, and Cal OSHA has its own standards that need to be followed, and they're more restrictive than the federal requirements. So really be mindful of what standards you have to follow, what standards are out there, and when they change, because the Cal OSHA standards have changed over the last couple of years as the science has evolved. So it's a lot to keep track of.
Okay, so the next question I think we'll go to, I think both Chris and Natalie. I think you guys had talked about addressing this together, and that is, so how do we consider FMLA issues, PFMLA issues, and the ADA requirements with a workforce who may or may not be at work on a day-to-day basis, maybe remote, maybe a hybrid? How do we coordinate all of that?
So I mean, as with any of these, time will tell. But it's, as more and more employees are returning to the workplace in person, there's, you as employers are clearly going to have some who are reticent to come back at all. And there will be some who, when they return, are going to suffer from a mental health perspective in a variety of ways. And so the ADA is definitely going to come into play with a number of employees out there. First of all, the ADA, it doesn't require an employer to give an accommodation due to just kind of a general fear of exposure to COVID-19. Employers are not required under the ADA to give an accommodation due to an employee having, an immunocompromised family member or a child who can't yet get vaccinated at home. But if an employee is suffering either from either the readjustment to the workplace, COVID concerns, an employer may have to engage in the interactive dialogue that always has to take place when there's a potential ADA concern, so that the employer can understand if there is a disability and whether an accommodation is required. The EEOC has expressly recognized that employees with mental health conditions such as anxiety disorder, OCD, post-traumatic stress disorder, may experience a greater difficulty coping with the stressors related to COVID-19, including those associated with returning to the workplace. And so it is very likely that you will have employees who need a reasonable accommodation under the ADA, and this could be unpaid leave, permission to work from home, schedule adjustments, perhaps either changing the hours or limiting the hours that someone works, and things like that. And so it's going to become a greater issue as people are returning to a workplace that many have not been coming to on a regular basis over the last 2 years. I found that employers are very hesitant to ask for medical documentation when we're talking about mental health concerns. And, I would just stress that I would not be. It is, to the extent that it needs to be determined whether there is a disability or a handicap or an accommodation is required. You as the employer should really understand what the situation is in order to best accommodate the employee. But, employers always do have the option of determining whether there is an undue hardship that a reasonable accommodation might cause an employer, which means a significant difficulty or expense, which is in the disability and handicap setting is a pretty high bar as compared to what I mentioned earlier in terms of the religious exemption setting. And so it's going to be one of those things where you're going to have to take it on an individual basis, and the interactive dialogue is what's going to have to take place. And, what I would say is that even if employees had been working temporarily on a remote basis, that doesn't mean that, and that remote basis may have limited that employee's ability to undertake all the essential duties of the job. That doesn't necessarily mean that the employer has to continue with that remote working relationship if it is true that the essential duties are not being performed. So, keep in mind that what was required in maybe the height of the pandemic, assuming that has passed, may not be, you don't have to necessarily permit the same accommodations under the law that you permitted due to whatever circumstances there were. And then, if you're in Massachusetts, you obviously have the Massachusetts Paid Family and Medical Leave Act. I think there's going to be so far, that's only been on the books a couple of years, and so far it's been mostly used for, giving birth to children, and and the time thereafter, and also some physical disabilities that have caused people to be out for work for months. But I have a feeling that there are going to be a lot more uses of the PFML in Massachusetts for intermittent or reduced working hours, which is permitted under that law. And so I think that we're going to see a lot more of those situations as as we return to the workplace in a greater deal. I don't know. I know, Natalie, you had some additional thoughts.
Yeah, no, thanks, Chris. And I think you definitely covered it. Just my 2 cents on the issue of employee sort of anxiety type issues with return to work. As you mentioned, an employee just generally saying, I am nervous to come back to the office might not trigger an employer's duty to engage in that interactive process, but something more than that might. An employee saying, I've had several panic attacks due to coming in. That there are no really magic words when it comes to requesting an accommodation under the ADA. And that's sort of just a general best practice across the board that employers should sort of be on alert when talking to employees, and when employees are raising concerns that sort of feel like they might be requesting an accommodation. And, as Chris said, asking for medical documentation is appropriate, and going through that undue hardship analysis, same thing. But at the outset, I think just being mindful that it might not be so clear cut as an employee saying, I need a reasonable accommodation. It might be something less than that, but still would require you as the employer to engage in that dialogue.
So don't mute yourself yet, Natalie, because that leads us next to the next subject, which is confidentiality and privacy issues. And I think it's come up in every one of the subjects we've already talked about. So why don't you talk us for a few minutes, at least through some of those issues, how we balance those confidentiality and privacy issues and amongst all of the rest of these issues and problems we're facing.
Sure, absolutely. So the EEOC considers employee medical information to be like a really broad category of employee information. So information about diagnoses or any sort of medical condition that the employee has, that information about that is considered employee medical information, and that has to be treated confidentially under the ADA. So in the context of COVID, this has raised a lot of questions about what exactly constitutes employee medical information, but a positive COVID test, vaccine status, information about requests for medical exemptions from a vaccine requirement, all of that would fall under this umbrella of information that should be kept confidential. So that type of information has to be stored separately from employee personnel files. It should ideally be maintained even physically separate, so in some sort of secure, separate file. And absent some sort of express authorization from the employee, that information should only be shared with a really select few group of people at the company, which would be managers and supervisors who are directly involved in assessing reasonable accommodations and handling like leave requests. So typically like an HR director. Second, first aid and safety personnel if there's a medical emergency and you as the employer have to divulge some sort of information that you know about that employee where safety comes into play. And then third, government authorities investigating ADA compliance. So it's a really narrow group of people within your organization that should have access to employee medical information. And again, just sort of bearing in mind that employee medical information is more than just medical records. It's sort of any information about vaccine status, test results, and sort of our advice would be to interpret that broadly and sort of protect all of the information that might fall into that category.
And I won't ambush you with this as a question, but I'll also raise the point that the same provision in the ADA that says you have to maintain that information confidentially also limits the employer's right and ability to ask employees, current employees, for medical information, which, you know, puts you into some difficult positions about asking about vaccine status or the need for exemptions, or in the case of looking into whether or not a COVID diagnosis could be attributable to workplace for the OSHA reporting, you know, how much investigation you can actually do. And, you know, again, that's too broad a subject, I think, for us to delve into here, but there are a lot of limitations. And you know, clients are advised to be very careful in how they do those kinds of analysis and ask those kinds of questions. I think just brings us to our last subject, and we have a few minutes left. I think we've answered all the questions in the Q&A. So just the last question we wanted to talk about a little bit, and really it's speculation, but what do we envision? What do we see as potential litigation, potential areas of dispute, potential problems going forward arising out of all of this? You know, I'll kick it off and start with one, and then I think, Chris, you raised earlier, and I think is definitely going to happen, and that is overtime cases resulting from people working remotely, right? It's not really a new issue. The idea that someone was working at home on their own, you know, on hours that aren't usual business hours. You know, they may be working on their computer at you know, from 2 to 5 a.m. and because they couldn't sleep, and now they're saying, well, wait a minute, I should have been treated as non-exempt and getting overtime for all that. Those are not new legal issues. I would definitely envision seeing cases like that. Any others? Anyone else?
I would just say that the unprecedented employee mobility we've had in the last couple of years that is showing no signs of stopping is going to just increase employment litigation across the board. Because, I mean, I'm sure you all have found that most of the cases filed by former employees are not the employees who worked at a company for 20 years, but more likely the ones that have been there only for 6 months or a year, because they don't have the attachment to the company and to the people, quite frankly. So, I mean, it's just a warning to make sure everyone's dotting all I's and crossing all T's in terms of complying with all the rules.
And I think one other sort of gray area that remains hanging out there is workers' comp. Early on in the pandemic, you know, we saw these statutes enacted in states like California saying that if an employee contracted COVID-19 in this specific window of a few months early on in the pandemic, it was presumed that it was work-related for workers' comp purposes. Those statutes have sort of fallen away, but recently, just a couple months ago, there was a decision, a case in California where the trial court found that the workers' comp exclusivity provision didn't bar a spouse from bringing a claim against the employer, where the employee brought COVID home and then the spouse became sick. So the trial court actually found that that wasn't a derivative claim or derivative injury. So sort of gave the green light for the spouse to proceed. I would note on appeal that the court didn't say whether the company had a duty to the spouse and didn't go so far as to say that the employee contracting COVID was definitely work-related or the results of some sort of employer negligence, not having safe protocols in place. But I think it still sort of raises this issue that we're not totally clear where the lines are going to be in terms of employer liability going forward.
Well, and I do think on workers' comp, early on when this question was raised, whatever, 2 years ago, when we were talking about about what litigation is going to arise, I think a lot of people, including myself, thought a lot of that would turn on what position and what the workers' comp carriers did. You know, if the workers' comp carrier insurers try to fight their exposure to these claims, to say, you know, they're not work related, then the liability would be pushed towards, or the potential liability would push towards the employers. I don't think we've seen a lot of that at this point. I mean, some here and there, but it hasn't been you know, that widespread. So perhaps, you know, perhaps that won't be as significant an issue as we thought. Anyone else? Any other comments before we go? It's just 2 o'clock now, I think. Well, I want to thank everyone. And Becca, thank you so much for joining us today. And I want to thank ACC very much. We really appreciate the opportunity to have worked with you again. And thank all the attendees. We are grateful for your time. Thanks, everyone, and take care.